Αλήθεια. Μου μιλάνε εδώ. Πού είσαστε? Μαρκέλα?
Σας ακούμε, είχαμε ένα θέμα με τον ήχο, τώρα σας ακούμε μια χαρά.
Ωραία. Εσείς θα πατήσετε recording.
Ναι, εμείς θα το πατήσουμε. Σωστά.
Γιατί έχουμε την πλατφόρμα.
Να ρωτήσω κάτι, αν διαμοιραστώ την παρουσίασή μου τώρα, θα φαίνεται και η εικόνα μου ή θα φαίνεται μόνο η παρουσίαση μου?
Ναι, και η εικόνα και ο ήχος και η παρουσίαση και η καμερά.
Antonis Angelakis, who is an assistant professor in the University of Crete in innovation policies in the Department of Political Sciences. Antonis has an extensive experience in innovation entrepreneurship in several subjects. And today he will give us a seminar on technology transfer and innovation from lab to market and society. And we are all ready to hear him. I close my camera and my microphone.
Okay, hello everyone. I'm Antonis Angelakis, assistant professor at the University of Crete, and we will talk about technology transfer. Precisely, the title of the presentation is Technology Transfer and Innovation from Lab to Market and Society. I would like to thank DxHub and Mrs. Kolokousi for the invitation, and I would like to thank the participants for joining us. The key message of the presentation is how we are taking knowledge and science from the research lab and bringing it to the market as a process, as a product, or as a service. So everything that makes us more efficient, more productive, more AI-enabled, more digital, more leaner, cleaner, greener. Innovation is based more and more on science and technology in the last decades. So this is a major aspect of the presentation. But it's more than that. It's how also we take knowledge and science and bringing it to the society at large. So how can we use science to tackle social challenges such as health crisis, climate crisis, food crisis, and several problems that we face. So ultimately and overall, science and knowledge is a key mechanism to solve problems around us. And technology transfer is a key mechanism as well to do that efficiently. So we will start with some key terms and definitions. Let me say a few words about the process, the procedure. Should you have any questions, please raise your hand. Questions is a good thing, so I will be very happy to answer those questions during the presentation. So questions are welcome. We will start with some key terms and concepts, some key definitions, and then we will see some analytical frameworks and key techniques on technology transfer and innovation management generally. There will be some concepts that some of you might already know, and as far as I know, there are also some seminars on this in this series that where you talk about IP and technology transfer, implicitly or explicitly. So I will not go in depth in several occasions, but I will have a sweep through some key terms in order to all of us to be on the same page. So let me say a few words about the seminar. So we'll provide valuable insights, strategic management of IP, of intellectual property rights. We'll pay attention on categories and types of technology transfer. By the end of the seminar, we hope that we will have improved the understanding of the innovation value chain and related processes. I'm staying just with the bold ones. The participant will gain strategically managing science-based research results, practical knowledge on strategically managing science-based research results, and we will analyze some innovation management techniques in several topics focused on R&D management, IP strategy, competition and market analysis, and several others. So some key definitions from WIPO, the World Intellectual Property Organization. What is intellectual property? It means the legal rights which result from intellectual activity in the industrial, scientific, literary, and artistic fields, and why countries have laws to protect it. IP, let's call it IP from now on. The first one is to give thought or expression to the moral and economic rights of creators, and the second is to promote, as a deliberate act of government policy, creativity and dissemination, application of its results, and to encourage fair trading. What is industrial property? Industrial property is part of intellectual property. Intellectual property includes copyright and industrial property. So industrial property covers inventions and industrial designs. Inventions are new solutions to technical problems, and industrial designs are aesthetic creations. So industrial property includes trademarks, service marks, commercial names, designations, and including indication of source and appellations of origin. So to wrap up the intellectual property definition, we have these major types of intellectual property. The first one is patents. Patents are based on new inventions. They are characterized, the major criteria, as we shall see later on, are novelty, inventive step, and industrial applicability. You have already talked a lot about that in several other seminars. And it is a technical solution for a technical problem. And they have some other attributes as well, which are that it's an exclusive right, is a negative right, is a territorial right, is a temporal right, and it's also transactional. It could be sold or could be licensed to somebody else, to a third party, a company or another research team. The second one is industrial designs, which is the external form of creation. Trademarks, which is a distinctive form, might be words, sounds, and so on and so forth. And of course, there are copyright and related rights, which are mainly creative forms. Then we have geographical indications and trade secrets, which are a very special category. Knowledge and information not publicly available. What is technology transfer? We could define technology transfer as the process of exploiting and transferring research and technological results stemming from scientific research to the economy and the society. Another definition will be that technology or innovation transfer, lately, is the process of moving an innovation from one entity to another. Let's say here that universities are key beneficiaries, creating technology transfer offices in that respect, that need to create awareness among researchers, educate researchers on basic technology transfer principles, and guide and support, I will add here, researchers that aim to commercialize their work. We can talk later about that as well in more detail. But the last years, the technology transfer scope has evolved. First of all, by encompassing non-patentable innovations, including liberal arts, applications, software, copyright material, social sciences, training and clinical programs. Secondly, by recognizing research as an open innovation process that is complex and fragmented, including several numerous actors such as users, regulators, and citizens. And thirdly, by considering open business models, we will talk also about that, in the commercialization of research. So far, we have some key definitions, and then we have some key aspects or some key types or categories of technology transfer. So the first category could be the technology transfer based on university-industry collaboration. Here we have, first of all, the so-called in-contract research, which is mostly focused on problem-solving research. The second subcategory is science-based and knowledge-intensive services, which is the provision of services, of science-based services from universities to third parties, to companies or to other organizations to solve problems or tackle social challenges, as I mentioned. And thirdly, it's collaborative R&D, research and development, which is a collaboration between a university and a company from the very beginning to create a research result. The second category is knowledge transfer through conference applications. I think this is obvious. The third and very important aspect or category for technology transfer is the commercialization pathway, let's say. So here we have three key definitions and three key categories of technology transfer. The first one is licensing, as we usually call it, licensing or licensing agreements. What is licensing agreement? Is the contract. Licensing is a contract allowing one party, the licensee, to use or earn revenue from the property of the owner, the licensor, who receives royalties earned for allowing its copyrighted or patented material to be used by another company. So we have two parties, licensee and licensor, okay? And the licensor receives royalties from licensee who uses and deploys the technology in its products, given the right that they received from the licensor. The second category is spin-offs. Spin-offs are companies established by academics and researchers to exploit the research results of their own scientific knowledge and research activity. And the third category, subcategory, is material transfer agreements, contracts, again, as in the first category of licensing, but here the focus is on the acquisition of various biological and research materials. The fourth category of knowledge transfer is executive training. It's knowledge transfer through education and training. So it's executive training, industrial PhDs, and some other forms of collaboration and dissertations. We will have the opportunity to discuss for some of those categories on the next following slides. So what is innovation? We could provide a definition here. Innovation is the transformation of an idea into a new or improved commercial product or an operational, industrial, or trade process. And of course, or a new organizational model or method. Innovation is not an invention, as invention is not a patent. Patent is based on invention, so an invention is a form of technological result that is protected by patent. But patent by itself is not also innovation. Innovation might include one or more patents. So we have three different forms in three different stages of the innovation value chain, which includes the invention. It's far from idea. Idea is the first conception, then is the invention, then we have the protection of the invention, which is the patent, and then we have innovation, which is the commercialization of the patent in congruence with several other patents very often. According to the definition of OECD and Eurostat of 2018, is the Oslo Manual. It's a well-established and well-known guide for measuring innovation. We have a new definition the last years, which is innovation is a new or improved product or process or combination that differs significantly from the unit's previous products or processes. And then we have two forms of innovation, the product innovation and the business process innovation. The product innovation is a new or improved good or service that differs significantly from the previous goods or services. And the business process innovation is a new or improved business process in several functions of the company, which include producing and delivering products for sale, logistics innovation, marketing innovation, product and business process development. So we can have several different types in different categories and different taxonomies, but the major ones are product innovation and process innovation, according to the definition that we just described. And sometimes we use organization innovation as a distinct way of innovating. So, for example, let's take pharmaceuticals, which are more we're more familiar with that, and it's more related to our project. When we talk about the product innovation for pharmaceuticals, we are talking about a new drug. When we talk about process innovation, we are talking about, for example, the use of artificial intelligence in new drug discovery. And organizational innovation for pharmaceutical might be a new program for collaborating with universities or a new business model. Innovation is not a linear process, but in order to understand innovation, sometimes we need to approach it as through the prism of a model. So we usually approach innovation as a process, theoretically, which includes the idea, the prototype, which is the first form that works, the technology that works, but not a final one, not the final version. Then we use sometimes this technology with some early adopters, as we call it, which are some entities, either business firms or individuals that might be willing to use the first version of a product and to give us feedback, provide us with feedback. And then when we will have the final version of the product, we can enter to the market, hopefully with a success. And so a simple way to see innovation as a process is to see idea, prototype, early adopters, and market. If you want to follow and to structure our thought, how we will move in the next stages. We should take into account that innovation has some attributes. Usually it's not linear, as in the diagram that we just presented. So there are many feedback loops between the several stages. The idea stage might interact with the market stage. So there are back and forth in all this process. So it's not linear. It's knowledge-centric more and more based on innovation and science and technology. It is influenced by the institutional environment. We know that innovation policy, for example, and the institutional innovation policy framework with the national innovation systems are a crucial parameter for supporting successful innovation cases. So institutional environment is a key aspect of supporting innovation activities. Innovation is conducted in innovation networks. And as we will see right now, open innovation is a very useful concept to work with within companies, but also within universities. And of course, innovation is increasingly produced through porous boundaries. This is also related to the open innovation concept that we will discuss in a while. How a firm may innovate. Let's take now the view of the firm. Usually and theoretically, firms, and mainly larger firms or technology-based firms, they retain an R&D department, and the most common strategy is R&D departments to aim to implement projects. Proposals for R&D projects may derive from top management, mid-management and employees, or external partners. And R&D projects should have a team, a budget, specific goals, final or milestones, and a project leader. Which are the criteria for selecting projects? Might be the time to market. First of all, I think that's existing R&D capabilities. Is the technical risk, and of course the commercialization risk, the existing commercialization capabilities. The existing production capabilities. The pre-assessment or assessment of market acceptance. The expected profits, obviously, and the availability of resources. And which are the key aspects of developing a strategic framework within an R&D department? One aspect is the architecture, which might mean that I would have a centralized or decentralized unit within the firm. I need people working on the R&D department or around that, having a draft strategy or specialists and generalists. So I should build a team, the portfolio, the ideal projects. I should build some projects that are aligned to my strategy as a company and aligned to my business model. And of course, there are processes. This is the how I will move on with my R&D strategy and how I will pursue development processes in that direction. So where, who, what, and how are key aspects for R&D strategy framework. A classic way to see innovation for years was coming through the closed innovation, as we call it, the closed innovation model. So according to the closed innovation model, innovation is taking place within the R&D department of a company, and sometimes in collaboration with some other employees from other departments, marketing or product development. But in the closed innovation concept, it was and it is in several cases and in several countries and in several sectors the dominant paradigm. Still, the idea remains within the firm, within the boundaries of the firm. So the innovation value chain remains as well within the firm. So from ideas to market is a process that stays with the firm employees and the firm processes. So the research stage, the development stage are things that are happening within closed boundaries. Since the approximately 2000 or 2003, 4, it was Henry Chesbrough that gave birth to a new concept. It is true that open innovation pre-existed as a practical option, but theoretically, open innovation emerged during the period as the use of purposive inflows and outflows of knowledge to accelerate internal innovation and expand the markets for external use of innovation. So in the case of open innovation, we have the option as a firm to exploit knowledge produced internally in collaboration with an external partner, or to use knowledge produced out of the firm to develop a product within the firm. So the open innovation is based on the idea that the boundaries of the firm are more porous, as we said, is more open, so we can further develop our ideas or further develop our products or services in collaboration with several parties outside the firm. So since then we have two options. The closed innovation, which is still the dominant paradigm, as we know. Innovation is happening mostly within the firm, but also open innovation is an emerging paradigm for companies and giving the companies the opportunity to work with R&D service providers, customers, suppliers, users, complementary partners, competitors, crowd, or communities. So here we're coming close to an end regarding the definitions, the key definitions, and I will give a snapshot about what we call IP commercialization process. The IP commercialization strategy includes usually the following steps. Submission of the invention or discovery to Technology Transfer Office when we talk about a university. Evaluation, assessment, or pre-assessment or assessment to determine technical novelty, IP status, and potential market value of the invention. The next step is the protection of IP. Then usually we will have a business case or a commercial plan. IP marketing, it is also a choice for the next steps. And then we will have the options to follow either licensing as the most frequently used technology transfer means, as we described previously, or to develop a product development plan, and then we will have a market dissemination commercialization plan to take advantage of it. So here we have a model to further discuss the commercialization process. It has been developed by the Technology Transfer Office of the University of Athens, Archimedes. I had the opportunity firsthand to work with this model during the last years as an innovation expert working for the Archimedes. So I had the opportunity to work with several research teams and applying and deploying this model. So, and now we are in discussion and collaboration with the University of Athens and University of Crete to create a new and extended version of it. So in the following slides, we will see some more details about this. There are three streams here. The model is composed by the develop, protect, and commercialize aspect. We will talk about R&D project management, which is the first stage. And there we will see another analytical framework that we will use based on open innovation approach. The second level, it is protection. And so we'll discuss about the prior art, the rights clearance, the patentability, the IP strategy, and the budget for IP protection. And the third stream is a problem definition, which includes the target group and end users. That might be different, and target group for end users. Competition, market analysis, commercialization model, and commercialization plan. And we will see the difference between those two. So which is the aim of this model? The model aims to mitigate the technical risk, the intellectual property risk, and the market risk. What is the technical risk? Is the uncertainty of whether a technology can be made to do what is meant to do, if the technology works. The intellectual property risk, if there is an infringement, or if there is a freedom to operate. So it is the uncertainty of whether the use of the technology can be restricted and controlled in a way that poses barriers to entry. And the market risk is related to the uncertainty of whether a new or existing organization is willing and capable of transforming a technology into products. So, and increase efficiency. So the model tries to mitigate simultaneously the three of these aspects. The first level is develop of the model, and in the work conducted in the lab, this is development. Usually it's conditioned by the scientific field. So again, I use a drug development case related to the project, the DxHub, I mean. So as you know, the drug development process, we have a compound development, in vitro testing, animal testing, sometimes clinical trial 1, 2, or 3. Obviously, this is related to timeline, budget, milestones, and partnerships. And of course, interaction with external partners are critical. And these interactions provide valuable feedback affecting not only develop, but also protect the commercialization stage. In the development stage, we will have the opportunity now to discuss and to present another analytical framework that might help. We have developed this analytical framework with several colleagues from other universities during the last years. It is based on the concept of open innovation. We had the opportunity to present this model first time at the World Open Innovation Conference at Berkeley, United States. And we had the opportunity also to publish some research papers, several journals after that. So the idea is this: with whom do I innovate with? As a company, I can work with the universities, or I can work with technology receivers or clients. I have the option to work with users, suppliers, complementary partners, communities, or crowds, so have different options of collaboration. And then I have in the horizontal bar, we'll see three options. In internal exploitation, so I might develop an idea, or I can work on product development or technology development. And the internal exploitation might happen within the company. So it's the internal exploitation is the first option I have, the strategic option I have. The second option I have is co-exploitation. So to build a framework of collaboration between my company and another company or a university. And the third option is external exploitation, which includes licensing or creation of a new vehicle, like a joint venture or something like that. So on the left side, we see the collaboration options that we have, either as a company or as a research team, in several stages of the innovation value chain. Might that happen to the idea stage, ideation, or might that happen to the development stage, or might that happen down the road toward the market. And on the right side, in the horizontal bar, we see the options that I have to capture value from my innovation, from my technology. which is internal exploitation, co-exploitation, and external exploitation. The second stream is the protection stage. At the protection, we have the prior art step. What is prior art? Prior art is the stage of reviewing patents. We are taking as a case the patents as most representative IP assets. So we could review patents by using, for example, databases, related databases, to see what is around and searching for, exploring the state of the art, as we say. So the first step is identify the closest prior art for patentability. And there we're trying to see if there is any novelty or inventiveness. The second step is to identify active patents that may be infringed during the commercialization process. And the third step is to use classification for business analytics to identify research competitors, market competition, or other technological trends. Of course, scientific literature is an option, is a technical task in researching for the state of the art. The second step is rights clearance. What means rights clearance? Is to define the who is who. Who is the inventor? Inventor is anyone who contributes in any way to the capture of the idea and the illustration of at least one claim of a patentable invention in a patent or a patent application. So he owns the moral right. The second major part of a patent, of the stage of rights clearance, is the applicant. He is the owner or the holder of the patent and the one who has the lawful right to file a patent. So it could be physical or a legal entity, inventor or organization respectively. And he holds the economic rights. So the basic questions that we should answer here is who has the lawful right to be applicant and how intellectual property rights are distributed among the applicants. And what we need to know here is the contribution of each inventor in the invention, first of all. Secondly, the inventor's obligations at his and their employer based on the contract they have. And thirdly, the IP inner policy of each partner. So rights clearance is a major prerequisite, a major second step in the process of protection. The third step is patentability. Patentability criteria are, if it is my innovation is new, my technology is new with respect to the state of the art, if it is inventive, as you know, considering the knowledge of the expert and the state of the art, and if it is industrially applicable. For example, a technical solution that can be scaled up in the relevant industrial environment. There is a secure option here, which is the opinion on the patentability derived from the search of report of a patent office, might be a national office or might be European Patent Office. Another definition here is the state of the art is everything that is public available in any way, written or other form at the time of first filing. That's why we have a priority date. And to have a solid patent, we also need to have clarity regarding the claims. The claims are a major part of a patent after the description and the rights clearance referring to inventors and several other information. Unity regarding the invention and details and experimental data to justify that it's sufficiently disclosed in the patent application. So the above criteria are crucial for filing a patent application. Where, when, and how. The next step is IP strategy. IP strategy should answer several aspects. The first one is how, and in the next slide we will see some more. What we mean by how? An innovation on the one side may be protected through a combination of intellectual property rights. The most of the products that we use, sometimes we know that they include more than one patent. So it might be a patent also, might be a design, industrial design, a copyright, or a trademark. So what we call in general IP assets could be part of the same product. So a combination of IPR should be part of my strategy to protect my product. Secondly, we need careful management on the relevant information, secrecy and management of lead times and so on. But however, we need to acquire as many intellectual property rights as possible to block competitor imitation, and that might be resource or time intensive, because as you know, protection is a very, especially resource intensive, both for companies and universities. And that's why we need a balanced and carefully managed IP strategy. Of course, IP strategy must be in coherence with the commercialization strategy. And if innovation is not patentable, my technology is not patentable, or my IP asset, then we should consider other solutions such as trade secrets. So then we should answer two more questions, which is when and where. When is referring to patenting as the main protection strategy. This is very critical. Timing becomes critical for protection strategy. Secondly, patenting early may prevent others from doing so, but patenting late allows a more detailed consideration, thus strike a patent. That will help us because we'll shift the expenditure closer to commercialization, and in some cases might reduce the relevant risk. According to where, given that the protection stage, the protection process is costly and resource intensive, we need also a balanced approach. So we should consider to have a trade-off between filing in as many countries as possible and take into account the relevant patenting cost. And then we have budget for IP protection. This is depends on the selected strategy. In most cases, the cost for IP protection depends on the cost of the preparation, the prosecution of the patent application. And when trade secrecy is chosen as the main IP strategy, the cost for IP protection may include additional tasks in the lab, so such as adding technical barriers that may hinder competitors for reverse engineering and several other techniques that they might use, or several NDAs or other aspects that I might use to protect my idea under trade secrecy. So we've seen the develop stream and the protection stream in a nutshell. So in the next stage, we will see the commercialization part, which is the third stream of this model. And I hope that it will be helpful and it will come in handy. The first stage in the commercialization stream is the problem definition. So the first step is to define the problem. We know that the research commercialization might lead to products or services. And on the other hand, products might be solutions, specific solutions to problems. So we have a wide angle view of, we should have a wide angle view on approaching the definition of the problem, which is related both to the technology that I am able to produce, but also to develop, but also to the needs that my technology might tackle. The second step here is the target group and end users. It is really important to know my value chain, the value chain of the industry. So my clients are not always the final users, the end users of the product. So if my technology is about suspension technology, advanced suspension technology, my client is not this funny guy here, the funny driver, but it is the motorcycle manufacturers. So I should know which are my clients, because my clients might not be consumers, final consumers, but other companies. So the knowledge of the value chain is really important. If the problem, for example, is related to a cardiac stress test, I use a health-related case as well. So the target group here is firms producing stress test equipment, but the users are hospitals, doctors, nurses, patients. So the next step is to understand competition, and that will lead me to the market analysis. So to understand competition, I need to understand that competition includes everyone that solves the same problem. Might not be a company from the same sector as in the sector that my company belongs to. So the key prism to understand that is to see who solves the same problem. Companies might solve the same problem in a different way or framework, and at the same time, solutions applied in a different industry might have many common characteristics. So competitors are all those who solve the same problem. We can learn also from competitive solutions. Prior art provides us a good basis, and we have now prior art since we have passed through the protection stage, and there we will have the opportunity to see possibly which are the competitors, the potential competitors for my product, and then benchmarking can be very helpful as well. The next stage might be market analysis. That will give me an opportunity to measure and to have some key figures about the market. And the market analysis, another health-related case, is to have the key numbers. So let's say that I have a population in several countries. My population here is 45 million approximately. And I know that 2 or 3% of the estimated population is suffering from a specific problem or a health problem, as scoliosis. So if my number of clients is the 45 million, millions of multiplied by 2%, we have potential clients of 900,000. And if I have an estimated price of 150 euros for my product, then the estimated revenues that I might have, I might earn, will be 136 million. But of course, I'm not the only one in this market. So the 136 million euros are the total addressable market where my product will enter. I have to take in consideration that there will be several companies in that market, so I will have a larger or a smaller part of this market. But it's good to know which is the whole market for my product. So another way to understand and to tackle challenges related to the markets analysis is to develop and to take feedback for my product through a functional prototype. A key term for this kind of functional prototypes is the so-called minimum viable products. Minimum viable products may range from a simple presentation to a functional prototype, and our research involves do minimum viable products and in turn the commercialization model. So 3 ways to protect ourselves from copying when looking for feedback, trying to understand the market, not in terms of key figures, but in terms of technical aspects. It's to present the results, not the technology itself as a black box, and leaving technology as a black box. The second one is to present the minimum viable product after the filing date. Of course, in the case the technology is patentable. And thirdly, to sign a confidentiality agreement, an NDA. And this option might be combined to the option A and B. What is the idea for minimum viable product? According to the classic approach of the waterfall approach, as we call it, the idea was that I should invest all of my resources to the development of idea, and hopefully I will have successful results. But on the contrary, if things don't work, I will not have any more resources. So the waterfall approach is not always compatible with companies or cases where either the resources are projects with which are resource intensive, or with companies which lack resources. So MVP is a solution and an alternative path, more lean, to release and validate solutions, to take feedback from the market or for several early adopters, to run some experimentations, and then to get back and to have another version of product or services. So mitigating risk of developing solutions that no one has ever asked for, and that is very good to know it early. The next two stages are commercialization model and commercialization plan. The difference between commercialization model and commercialization plan is that the commercialization model is mostly the equivalent of the business model. It's something like a short description of what I'm going to do with the product, the technology, or my company. The business plan is something more detailed. For the commercialization model, first of all, we will use another model, the St-Gallen Magic Triangle of Gassman, and several other authors, which tries to answer four crucial questions: what, who, how, and why. So the first question is what we are selling. If we want to build a commercialization model, we should answer those four questions. The first one is what we are selling. So in what we are selling, we should define the problem, and we should define the value proposition. The value proposition is what our product offers to the market and to the final user, to the end user. The second level is who is buying and who is using. So it might be a business, another business, as we just discussed about the suspension technology. It might be consumers or citizens. It might be a government as a client. So the second question is who. The third level is how are we selling? Which are the major means of technology transfer? This might be contract research, might be collaborative research and development, consulting, licensing to promote, to pursue my technology through licensing agreements with third parties, product services through a spin-off, a creation of spin-off, or training. And the final one is the revenue model. How can we earn? How can we capture value from our technology? That might include royalties, lump sum, subscription, or several other forms such as fees. And the commercialization plan, it is something more detailed, as I said, which will further analyze aspects of the commercialization model. So some key lessons from this the presentation of the model that includes development, protection, and commercialization. The first one is that it is important to have the opportunity to break the silos of the lab for an early stage. That might increase the complexity of managing the process, but it will significantly improve the likelihood of a positive outcome. The second key lesson is that we should systematize feedback and iterate within and across streams. So it is very helpful to have feedback. The feedback adds agility, might improve resource efficiency, because I have some knowledge earlier and I will avoid mistakes and wrong choices. And of course, accelerates commercialization. The third one is that through this kind of models, I can combine the knowledge of people with their different mindsets. So I can mingle research knowledge, legal skills and insights, and business skill sets. So the combination of knowledge across the three streams is a very important aspect to create feedback loops and to optimize the choices that I make at each stage. And the fourth lesson might be that it is important to promote validated learning through experiments that are actionable. If you're going to fail, do it fast and learn fast by that. So, for example, the minimum viable product solutions, the minimum viable product approach helps to have a feedback early, so to have some fine-tuning in my actions, in my strategy. Some key topic focused and let's say take-home questions will be, and we could discuss those during the seminar and just after my presentation, is why do we protect intellectual property rights? Why it is important to protect it? It is important because it gives me the opportunity to capture value from my technology. Yes, this is an option. Is something more? It is important because I want to start a company. This is my only option. I could follow another alternative like licensing. If I want to capture value in some ways for my technology, the first step is to protect it, to protect my IP assets. So IP assets is a key method. IP assets protection is a key method if I want to capture value from my technology, economic value or social value. The second question is why intellectual property rights are key assets for companies. Do they increase the value of the company? Do they provide some more options regarding their collaborations? It is good for the brand of the company. So this is a very multifold questions that we could answer and discuss. The third question is why companies follow open innovation today. Why is open innovation an option? Open innovation might help me with the need to have economies of scale, for example, or might help me to find talents from the external environment, or to find resources and blend resources with other companies or universities. Open innovation might help me to find research results and capture value from it through a licensing agreement or another form of collaboration. Open innovation is becoming more and more a strategic option for companies. And in order to understand which are my strategic benefits from open innovation, I should first understand why it's important for me as a company to follow this path. And fourthly, why innovation management is important for universities and companies. Innovation management is becoming more and more a central aspect of companies, of course, but also of the universities through the technology transfer offices and innovation units. This is happening because science and technology is becoming more complex, first of all. Secondly, science and technology is coming from everywhere. So there are a lot of universities and research teams in each subject and companies producing technology and science, and this is available through several channels. So there are competitors everywhere. So it's good to taking advantage of my technology and to capture value of whatever I have as an IP asset or as a technology. But also it's a technical and cross-cutting topic. So innovation management includes legal aspects, but not alone. It includes also technical aspects, business aspects, management aspects, things that are related to the market and the market potential. So since it is a cross-cutting topic, innovation management is becoming lately a distinct subject of science. So we have innovation managers who their role is to efficiently help their companies or universities to identify, to spot, to analyze, to protect, and to commercialize their IP assets. But there are some key macro questions on this. The first one could be, can we manage and exploit knowledge, research results, and innovation? Is something that we can manage it, or is something that we should leave it to take its path? Or it is something that only the researchers are responsible for that? Or do the researchers need support in this process along the way? Which are the more efficient techniques to manage technology and knowledge? Relatedly, how can we accelerate research results and knowledge exploitation to tackle major social challenges? Because as we said in the introduction, the market path is one option, but another option, complementary sometimes, is the social aspect, is to tackle social challenges. So which are the ways through which we can accelerate the research results to take their route to tackle social challenges? The third one is how the rapid advances of science in recent years will lead us to economically and socially valuable applications. So something might be very business-like and very final product that will find it's very commercial and very valuable in economic terms, but also sometimes at the same time might has a dual use, solving a social problem. So how can we combine market and social aspects? And how we can make human lives better through science and technology? This is a more macro question as well. Finally, is cooperation an aspect for innovation? We know that nothing worth doing in the innovation field can be done alone. It's so complicated, it's so multi-level that we need to build collaboration around our research team or around our company. So cooperation is a major aspect of enhancing innovation today, but it's something that we can discuss as well. So as far as we see the last years, the emerging challenges we are facing as a society, and that's why coming to a close, to come to an end to this for this seminar, I would like to say that the emerging challenges we are facing the last years are more cross-cutting, so are involving environmental, technological, markets, and several other aspects. And in that respect, the solutions that might be available through technology might be also cross-cutting. And this is a framework through which we can think about to support technology and science during the next years, in the years ahead. So for the moment, I want to ask if there are any questions or if there are any aspects or topics that we like to discuss from this presentation?
I have a question.
Yeah.
Let me share my face. Okay, I have a question with patents. For example, I have a small company that makes a innovative product. Let's say I make an innovative, I don't know, battery, for example. If I want to patent this product, it might be good for my company because maybe I will sell my company and say I have a patented product. But on the other hand, I will need a lot of money to patent my product. And how long is this patent lasting? Which means that if I patent the product, everybody can find this patent. He will really read because I have to write everything analytically inside
Yes.
and be able to make my product in a country where it is not patented. It is not protected by this patent. Or
Yes.
it can make my product as soon as my patent expires. Yeah. So a small company, is it good to go for a patent, or it is better to keep it as a trade secret, whatever they make?
Yes, this is a key question. Patenting is a resource-intensive process. Yes, that's right. Secondly, patent is not the only option. Patent is not panacea. So I could have different options because I might not have, put it simply, I might not have the money to go through the patent process. And the patent process might take some years as well. So as we said, also patent has a territorial aspect. So I might patent in one country, but this is the country where I will be protected. But if I want to have my product produced or sold in several countries, then I should patent in all of those countries, and that might be more costly for me. So for a small company, this is true. It will be very difficult to go through this process. I'm not talking about the national phase, of course, for example, in Greece or in Portugal, which is much easier. But we're talking about the European level through the European Patent Office, either through the unitary patent or through the classical approach, let alone the WIPE and the PCT process, so which is much more expensive. All this because you then have a national phase and so on and so forth. So yes, the idea is that I should be very careful about where I invest my resources when we're talking about patents. Take into consideration that one patent might not be enough for deploying a product because a product might have more than one. And take into consideration also that even when I have a patent granted, I might have to invest resources in case of infringement, because as we said, a patent is a negative right. So I will be the one who will spot, find, identify, and know that there is an infringement for my patent for another company. So that might be also resource intensive. So it's not an easy task in economic terms. And I should be sure that as a company that we should be sure that our products will pay off in that respect. So which are my alternatives? Yes, trade secret for smaller companies, as far as I know, not the technology-based ones, but for the rest of the companies in several sectors, trade secret is usually a more simple solution. It is based on the first mover advantage, in the sense that I will be the first one who will bring the product in the market. I don't have a patent, I have a trade secret, and if somebody learns how to make it through reverse engineering or through another way, okay, I will have already built a position in the market. So I will be the more competitive in that terms. But or like I should have built a brand, or I will have a major position in the relevant market. So it is also sector related. If I'm going to answer your question in detail, I will say that it is also sector related, in the sense that if your business is in the pharmaceutical sector, sometimes it's impossible not to go through a patent process because, or in the biotech, because this is good for several reasons. Patents might help you. It's almost compulsory because you need to protect your science-based technology. This is the major, but also it will be useful because patents might attract investments. So when we're talking about technology-intensive companies, usually it's more useful to have patents, even if it is costly. In other sectors, yes, you might combine several techniques and categories and types of IP assets that are not that costly, and you create an uncertainty regarding their payoff in a short and a long term. I don't want to forget to comment what you said about that through my patent I describe everything in detail. Yes, the patent is to describe everything in detail. It's not to hide something. On the contrary. So when you file a patent, everybody will know how, having the prior knowledge, as we say, everybody will know how you're making it, how you constructing your technology, you make the technology. So after the patent expires, usually 20 years, I didn't mention that there are several protection periods for different categories. The patent is usually 20 years, with exceptions, of course, depending on the sector and the specific characteristic of the technology. In pharma sector, for example, we have several different exceptions and periods for several drugs. Then we have some other strategies that are used. In the industrial designs, there are 25 years upon renewal. And in trademarks, for example, last forever upon renewal. So there are different last protection periods. But let's say for a patent that the period that you have to capture value is maximum 20 years. So within those 20 years, you should have developed your product, pay off, and to have a dominant position in the market, because after the 20 years, the patent expires. And for example, in the pharmaceutical sector, we have generics or some other forms of competition, and that will affect the price the price level and the number of competitors in the relevant market. I don't know if I answered your question. It was really insightful, your question, and thank you very much for that, because it gave me the opportunity to go a bit further in further detail about those aspects. But I hope that I answered your question adequately.
Yes, thank you.
I hope that we will have some more questions.
That everything was very clear.
Clear and fast, I'm afraid, but okay.
I think that was okay. I mean, it was very structured and with a lot of subjects that you touched upon.
I tried not to go in depth in several aspects related to IP because we had already a seminar, as far as I know, on that. So I tried to sweep through that without much detail, but I tried to pay more attention to the market aspects, maybe. If I had something to say, is that it's a very complicated process. A patent is not the only way to the market, secondly. Thirdly, for companies that need to protect their IP assets, certainly it's out of question that they will need help from innovation manager or patent attorneys or innovation experts from different disciplines. For example, you will need a patent attorney for protection, but you will need a market analyst or innovation expert for the commercialization aspect. So even in that dimension, not of the technology, in the technology itself, but within the supporting mechanism that you should build in order to accelerate the commercialization of your technology, even in that direction, you should combine different set of skills. So this is very important in innovation management today, which compile several aspects of those disciplines, constitutes a rather distinct subject for their masters on that. There are several schools and universities providing curricula for learning how to do this job of innovation management. So certainly you will need help. You cannot do it by yourself as a company. Of course, mid-sized and larger companies have their own departments on that. But even very small companies, which are the majority, the major part of the economy, need help on that direction, and they are receiving support from the external environment, either from the market itself or for supporting institutions such as science and technology parks. So this is very important that we have also several mechanisms such as science technology parks to support this kind of companies. This is their role. But one way or another, IP assets will be either if we want to protect it or not. IP assets will be a major part of the economy that is emerging now. So we will have more and more technology-based companies and science-based companies, and what we call deep tech. It will be every year a larger part of each economy in the Western, in the global economy, in the developed economies and the less developed regions of the world. So as long as we will have more companies, more deep tech companies, the more we will need this kind of tools and this kind of aspects to be managed efficiently. So our role is to diffuse knowledge about that and to help people understand and clearly and efficiently manage their IP assets in a way that fits with the strategy of the business of the firm or the research team. And protection is not only capturing value from the product that I will develop and deploy, or the process. Protection is about having the ownership of my knowledge, even if I choose to license it to another party, to another company. So it is a way not only to be an entrepreneur by myself, because I might be a researcher and not having the will or the resources to be an entrepreneur, but it's a way to capture value by giving the right to somebody else to have revenues from my technology and me to receive royalties, or having another type of licensing agreement with different parties. Especially regarding the IP assets, it is an aspect that usually is discussed during meetings with investors, venture capital investors, for example. So it is part of the discussion, and it's part of the business plan always, or a commercialization plan. And if you are searching and seeking for funding, it is obvious that people that are going to invest in your company will ask you how are you going to handle the IP asset and how your IP assets are well protected, and not only in terms of hard technology, but also what will you do with software, what will you do with the trademarks, and so on and so forth. So IP is here to stay, and of course, organizations like and programs like DxHub, I'm sure that will provide well-defined and concrete solutions and services to people that looking to protect their IP assets and to commercialize them across the market.
Yeah. Well, it was not only the IP. I mean, you gave us now very many insights into the protection of the ideas, but the truth is that you gave us a very structured and way of thinking of how we ideate our
Ideate, yeah.
projects. Yes, and the collaborations we can have with several stakeholders, either other companies, other labs, the society, how we protect them, where you elaborated a lot now, and also the commercialization plan that is also very important, because most of the times you need to start thinking about commercialization from the beginning, because you need to know whether there is a market for your solution, whether the clients will buy it, and then reach actually the business plan and the commercialization plan that was very analytical also in your presentation. So I think this was a very helpful, insightful planning for the way DxHub is going to work, and especially working in new projects and collaborating also the academia with government and the society to bring new solutions into the market.
Yes, exactly. And if I should keep something from this presentation, there will be a twofold insight as well, adding to what you just said, and I totally agree with, is that IP protection or IP issues are not only about protection, it's about strategy. So IP is a strategy. It's not only a legal topic. It is also a strategic topic. What I will do and not what I will not do, it is a strategic choice. So I'm staying with your first question, which was very insightful and helpful. Even if I do not protect my IP asset, it's a strategic choice. I could follow another path, yes, but so IP is a strategy. Legal aspects are there, of course, especially when we are talking about the protection stage, but from that point on is a strategic issue. So this is the first comment about that hubs, supporting mechanism could help on approaching IP not only as a legal procedure but also as a strategic and business procedure to the market. And the second comment, if I could say that, if we have the time, is the ecosystem that, as I said, it's impossible to be alone in all this technological and business landscape. So you should be aligned with the ecosystem, either the DxHub or the organization behind around DxHub or supporting mechanisms, because the ecosystem is out there, and through the ecosystems I can take feedback, I can combine resources, I can receive investments, I can find external partners for my products to develop my products. So the ecosystem building approach and the ecosystem embeddedness for my company or my research team, and DxHub is part of the ecosystem already, it is an important role that this mechanism might play and take during the next years. So IP as a strategy and IP as a means to be aligned to the ecosystem and build on this. So there's two more comments on that. And a third one, if you like, is that take feedback today, not tomorrow. So the MVP solutions, for example, and several others that we discussed, and the feedback loops, that the innovation is not linear, all this help us to have a feedback, an idea about how to make a fine-tuning and finely grained solution, not at the last stage, but at the first stage, the initial stage. So that I will save resources through that, and I will save time through that, and I will have a better solution, maybe more focused. This that my three more comments on that.
Thank you very much, Antonis. Are there any other questions somebody wants to ask?
As far as we wait, it goes without saying that the pharmaceutical and the biotech sector, as many of you know already, and better than me, it is an IP intensive sector. So for the sector, I'm talking about the sector that the DxHub belongs, is part of it. So IP could be a very important aspect for the next years and for DxHub to have a concrete idea and a concrete set of services in that direction.
Yes, indeed.
It's not only drugs, it is also therapies, it is digital health, it's devices like kits, as we discuss a lot about that in the DxHub.
Dimitris has raised his hand.
So thanks, Adonis, for the presentation. It was quite insightful. Can you hear me?
Yes, of course, and I'm very happy to answer your questions.
Yeah. So can you give us an idea how the technology transfer offices in Greece actually evaluate whether an innovation qualifies as an innovation? Are there specific mechanisms? Do they actually come close to other experts? Do you know something about that? Or are there any differences with Portuguese universities that our partners from Portugal can tell us?
Yes, thank you very much. I don't know if I could answer your question from the aspect of the Portugal.
Mm-hmm. No.
I have an idea, but I'm not sure because things are changing all the time. So I have an idea for several countries, such as Germany, Sweden, United States, UK, and Portugal, but not much. I'm sure about as sure as I can be about Greece, about the Greek experience, because I'm somehow involved in those activities at the University of Crete, and I had this opportunity also in several other universities, including the University of Athens, through which we had the opportunity to apply this model that we just presented. So the case for Greece is that after a long path of opening and closing technology transfer offices, as you know, I think that we are pretty the same age. So as you know, during the 2010, something like that, there were some technology transfer offices, some programs in Greece supporting the TTOs in universities. But that was in the framework of programs, and then back then we didn't have the, let's say, the internal policies for at least not all the universities for the technology transfer procedures. But for the last 7 to 8 years, we have a more concrete approach, well structured, and we have policies, if not in all universities, for the most of them, I know that we have IP policies, IP strategies for the universities, and we have, besides the rules and the regulation, let's say, we have mechanisms, we have structures, we have units, we have technology transfer offices themselves. So the process is that usually you will see that you will find out that we have some technology transfer offices working with sometimes together with some accelerator. So the technology transfer office supports the protection stage. If we are talking about based on the model that we just presented, the technology transfer office takes care of the protection stream mostly. And then some universities have an accelerator or some other mechanism to support a proof of concept, for example, to support the commercialization phase. Based on my experience, the university, we have 3 levels of support. At the University of Crete, we have the first level is the research support office, which is supporting researchers to get familiar with research funding, European funding, and so on and so forth. We have included already this aspect in the technology transfer office, which is important regarding the secure funding, the funding access. The second level is the legal support office, which is mostly the protection stream. So legal support office is IP support and spin-off support, how to protect your IP assets, to evaluate, to assess, and then to make a proposal to the research team, which are their options to move onward. And at the case of spin-offs, we have a process where we meet the team, we discuss with the team, and we're trying to develop and to we are developing a first, let's say, business model or a business plan. So in a nutshell, to wrap up, the technology transfer office, we call it innovation unit, innovation technology transfer unit, includes the technology transfer office, which supports the researchers themselves with several commercial-like services like business plan, business model, market analysis, and so on. Legal services supporting the researchers for IP-related topics, and RSO, Research Support Office, supporting funding. So if you give me one more minute, I will say, to be more precise regarding your question for the assessment. The assessment is really difficult to have an assessment for the IP, for the technology itself. So we're trying to do so, but I think it's the valuation, let's say, or the assessment is one of the more difficult parts to go through, because you should take into account the state of the art. You should take into account some aspects that more, let's say, not that tangible, are more tacit. For example, which is the value of the similar product which is already in the market or something like that. So which is the TAM, the total addressable market. So you go with some guesses, but it's difficult to have a concrete number or to have a specific break-even point, let's say, for the technology regarding the market rates or the technology trends. So I should confess that it's difficult, but we're trying to do so with several cases already. Just to mention that yesterday we had a meeting. I cannot say more, but yesterday we had a meeting with 2 cases in that respect. One for an IP asset and one for a spin-off. So it comes very often. The discussion comes up very often. The discussion to how to assess what I have in my lab and how to evaluate it and if it is worth to go through protection or not. Several times we work with external experts. And as far as I know, the most of the technology transfer offices work with external experts because it's very complicated and very sophisticated work to do. So we have some external experts and we'll work with them from time to time. And I can give you this information as well. As you know it already, it's not a secret. Regarding the technology transfer offices in Greece, there is a new period that's starting now. On top of that, will come an extra funding from the next 4 or 5 years, supporting their operations and providing them with the opportunity and the tools to work more with experts in that direction, because it's something that it is not always possible to handle in-house, let's say. I hope that I'm trying to answer your question. I don't know if I gave you an idea.
I think
well enough. Yeah, that's true.
I think we could ask Pedro. I don't know whether he has the opportunity to talk, to give us the Portuguese technology transfer image, because they are very well organized and have a very interesting programs that they do in Portugal. I'm actually impressed from what he was describing me last time. So there he is.
I'm sure that we will have a lot to learn from Pedro in Portugal. And we are comparable cases, above all, in terms of the size of the country and the number of universities and so on. So I think that we have a lot to learn. While waiting, I could say that I think that we are in the peak of the technology transfer office's maturity in this country. For the last 20 years that I'm following this subject. So the more are yet to come, as we say. The best are yet to come, sorry. And now the researchers
we cannot
also
hear
are
you.
more,
You hear me now? No? Oh, now you can. Great. I was having issues. I'm sorry. I can tell you, what can I tell you? I can tell you that in Portugal, it's something that the tech transfer offices, it's quite recent, especially this, I would say, a boom for all institutions or most institutions having tech transfer offices. We had one person, our office started 5 years ago. We one person, and just this year we have 4. And it's hard to compare tech transfer offices within Portugal and, or I might guess within Portugal and Greece and even other European countries. Just to give you this example, some TTOs that I know from the most developed ecosystems in innovation have departments inside the tech transfer office. So you can have 4 or 5 departments with 5 to 10 people working in each department, and we are just 4. So it makes me feel like we are kind of what we call a small office that helps, and for many people, it's already a lot of people. How are we structured, or how most of them are structured? They're structured might be structured into different ways. One is what we call cradle to grave, which is having people supporting innovation since the beginning, scouting technologies inside the university, talking with researchers, attending seminars, and seeing if you have something interesting that might that could possibly become a product or a service, for example, to understanding what's the value of that, checking if you have what is the IP strategy, if it's having a patent, if it's a trade secret, whatever it is, creating a strategy for it, and moving forward with the process. And you can have something that is more specific. There are TTOs that are organized in specific tasks. For example, you have a person who's specifically dealing with discounting and patenting. Once you have a patent, that the work of that office stops, and you start having, for example, the work of a business developer. Once you have the business developer and you form a company or find a company that's interested in the technology, and you start negotiating a licensing agreement, you pass that on to due diligence team, for example, who will be looking at the agreements, the clauses, due diligence / IP team. You can have also a department specific for spin-offs, for example. So you have people specialized in forming a company, developing business plans, looking for funding, creating teams, and all of these expertises are split within these teams. In my team, and I would say that probably most teams that are starting in Portugal and Greece, they work in this model of cradle to grave, where you have people that follow the projects from day one till the end. I don't know if there's any other more specific question from what I told you regarding organization or something else, TTOs.
I might ask, what's the level of collaboration, maturity, and acceptance, and networking within the universities for those technology transfer offices are something that is very well accepted, and do the researchers work with it a lot, or you are hunting for researchers, or the researchers hunting for you?
Yeah. So in the beginning, when you start an office, you need to go after the researchers, and there are strategies for it which aren't that hard. One of the things that I was telling you is attending seminars, for example, having lunch with researchers, just sitting on their table while they're having lunch and starting to talk. One of the things we did to proactively scout was to create an internal fund to support translational research. So we have 200,000 euros per year to support 4 projects that want to develop the proof of concept, so 50,000 per project. We open applications, we have an external panel of reviewers, and then they have 1 year, the winners, to implement that project and try to increase technology readiness level. When you're giving money to the researchers, they want to talk with you. So they come to our office, they say, I saw this call that you are managing. I think I have an interesting project. What do you think of it? How can you help me? Even if the project's not suitable, for me, it's an opportunity to interact with the researcher, understand what they have. It happened many times that we said, okay, let's apply, but also you already have results that should be patented, because if you want to publish that paper in 1 or 2 months, let's protect it. So it's an opportunity to educate the researchers. These days, what starts happening is that because they had all this process after these years, they are knocking on our door already. So whenever they have a new project, a new interaction with the company, or whatever that's related with us, they send us an email and they ask for help. So in the beginning, very proactive. If you do your job well, you start suffering from the problem that now everyone's knocking on your door and you have to start working only passively because what you have it's enough, or sometimes it's more than you can accommodate. And we are mostly on that stage now.
Okay. That's very good. And how do you handle the issue that Dimitris raised regarding the assessment of the patents?
Okay, so what do
Have
we
a common
do?
approach of that? Yeah.
Yes, I have a workflow. Maybe I could share with you, but I would have to search it. It would take a while. Maybe we have a workflow which is something like, from whatever reason that we start, that we have information that there's something that is interesting, some piece of research that is interesting. We book a meeting with the researchers and just talk with them. And it starts with a conversation to understand what they have. And first thing is to see what you have is a discovery or what you have is an invention. Did you just discover how this gene works or whatever? Or do you have, by knowing how that gene works, now you can create some kind of a tool, or you can make a drug development for a new target or whatever, and then you have a technology.
Yeah, because discovery cannot be patented. Yeah.
Sorry?
Yeah, because discovery cannot be patented. So that's why.
Exactly.
Just for the audience.
Yes. So first thing is to have that talk. If we think that what they have is interesting, we ask them just to send us information. We have a form that I personally don't like much, but we have what we call an invention disclosure form, where people just write a title, it's an abstract, what's their discovery or their invention, who do they think that could be interesting, what are potential markets. I mean, it has a few questions that they try to write it down, and that feeds us to do some homework. And the homework is to create a recommendation for patenting. Generally, it's not a recommendation for patenting, it's a recommendation to proceed, which is, we look at three main dimensions. One, market. Do you see an application in here? Is there people that would be interested? Does this serve any purpose? How does is it something that people urgently need? Does it have a broad enough dimension, or will this just affect 100 people in the world? And how important it is. So we try to look at these three dimensions: importance, urgency, and broadness in terms of the market. And we as Tech Transfer Office, we look for information that can help us make this assessment, and we create a report for the researcher. Second thing, patentability. I mean, you can have a huge market and it could be very interesting, but if there's already things patented, if they are disclosed and they cannot be protected, you won't have investment in the end, because no one will invest in something that they cannot assure they have the monopoly for a while. So that's a killer. So we make simple, I would say, freedom to operate. We look at the patenting landscape. We look at papers online. What is it out there about that technology, and just identify a few documents that we think are the closest to what they are describing, and give a recommendation if we feel that there is space in here to protect this, and this, or there's just no space in here. And the third thing, and for me one of the most important, how committed is the team with continuing the technology? You can have something very interesting, very patentable. If you have a retiring teacher whose lab is going to disappear in less than a year, just forget about that technology, because no one will continue working on that. No one will push that forward. So it just doesn't make sense to spend time on it. Publish it. It's interesting for what it is, just not to continue working in terms of translation. If we have these three things, if we have a go on these three things, we send a recommendation to the researchers saying, okay, this is our report. We feel that this is something we should pursue. And just opening brackets here, I'm saying this is very rigid, and sometimes this is very iterative. There are more meetings in the middle. While we talk and while we produce the reports, we talk with the researcher, we ask what's their opinion on this in order to close a final recommendation. And if it's that, what we are now starting to use is using the innovation readiness level framework to monitor these projects, which basically is looking to a few dimensions of a project like funding, team, customer, IP, technology, and have regular meetings with them once a month or once every 2 months, follow each of these dimensions and try to see what's there to be done in order to push the technology to the next level. What do you need is to understand what are the regulatory needs. Okay, let's break some work. As researchers, look on your end, what can you find? What does the technology need in terms of regulatory? We will look for our contacts and try to have that insight. If we need more than that, let's find money to buy some consultancy time in order to develop a validation or a regulatory roadmap. If it's something else that you need, which is understanding exactly what is your market, how can we do this? First, let's try to talk with people that we know. If that's not enough, or once we have some idea, maybe we need to hire a company to make some market study so we can segment very well our market, for example. I'm just giving these examples to get out of what is the development of the technology, because most of the time the technology needs to maturate, and that takes time.
So somehow you're giving them some prior art search report. Prior art search report. This is what we're describing, yes. Partly. So you're giving them something like a prior art search report and something like market analysis. So both of them.
Ideally, what I would like for it to happen is that we do that work and the researchers do that work also, and there's some complementarity in it. Because if they rely only on us, we might definitely miss some things, because they are the experts and they know the papers better than we do. So we also ask them to find and to give us that bibliography. But we also do that. But we do that now because we have 4 people. Because when we were 2 or when we were 1, we couldn't do this for all the projects. We just needed to be very picky on the one that we feel that is very very interesting, and we would dedicate more time to that one.
This is brilliant.
With more people now, you can dedicate to more projects, so you can put your eggs in different baskets.
Okay, let me use your answer to answer also to Dimitris, that we are in the grasp of that. So we are doing some work of that, for providing some search report to the researchers, but not that structured as a final search report. So as the one that you're taking from an organization for IP granting. So we are trying to do that work, and I hope that soon we will be there. I know that 1 or 2 universities are far ahead in terms of search report, a final search report, more completed and more extended. But this is the way that we're trying to go through as well, Dimitris. So search report about state of the art, what is out there, and what is the technology, and if it is worth of it, and some market analysis then about the TAM and so on. But the first one is what I mentioned as a more difficult to evaluate. But I'm very happy to hear that you have you've been a lot further in that direction. So I was sure that we will have a lot to learn from you. Thank you very much for this detailed description.
Okay, I think we learned a lot in this masterclass, and we also had a very good collaboration with the technology transfer offices. So I would like to thank first of all Antonis, that gave a wonderful lecture, and all of you that you stayed up to now. and see you in the next one then.
Thank you very much for your time and for inviting me. And I hope it was useful. A bit.
A lot.
Yeah. Okay.
Okay. Bye-bye, everybody.
Bye.
Right.
Thank you very much.